Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk.
5 minutes, Mr. Alessi. I'm going to prohibit you from mentioning ACCA in your opening statement.
How did the first week of Karen Reed's trial go? We have a special guest who wanted to be on our defense team, but he's here with us today.
While we wanted him to be on the defense team, we're lucky that he gets to be here today with us on About the Law. I'm Lainey Law.
And I'm attorney Andrew Myers.
And we have the good fortune of being joined by Mark Bederow. Mark, thank you for joining us today.
How are you guys doing?
Great. Good to see you.
It's been so crazy with the trial starting. I am very excited to hear what you had to think about the opening statements. My jaw was kind of on the ground, so I'm excited to hear your opinions on it.
Yeah, let's watch a couple of short clips, not the whole thing, because I know that you've watched it. Most of our viewers have probably watched it by now. Let me just play a quick clip of Hank Brenan's opening statement.
At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat, he raced to his equipment, and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter and paramedic, that means that a person's heart has stopped.
Attorney Bederow, there are a lot of different ways to do an opening statement, a lot of different styles. Obviously, Mr. Brenan chose to do the storytelling kind of thing. He started with the alarm going off in the fire station, and he went all the way through what happened at Brockton Hospital. Your take on the style and the approach Mr. Brenan took?
I mean, I like the idea of walking around a little bit and trying to communicate with jurors. I like, in principle, the idea of storytelling or using little vignettes and to grab their attention. But having said all that, I don't know what the hell that was that we just watched. First of all, to open with this story about the dutiful, dedicated firefighter Timothy Nuttall and making him the first name that the jurors are going to hear, which was then followed up with making him the first witness, a couple hours later, when he was so obviously going to be a terrible witness. He was a terrible witness at the first trial, and he was worse at the second trial. So I don't know what that was. I don't understand what he was doing, to be honest with you, in what you just played.
Well, that begs the question before we get to Alan Jackson's opening, which, to be fair, we're going to play a short clip of that. But that begs the question, if, as you say, Mr. Nuttall, who was the very first witness, was not so great, and then they had Kerry Roberts, who did not fare well on cross-examination, the old theory of primacy and finality, if those were the two best witnesses to lead off with, who is the prosecution's best witness?
I don't know. I don't know that there are any great witnesses. I mean, I don't think the key parties, certainly inside the House, when they get to them, they've got issues, certainly we're all familiar with. The former state trooper and the current state troopers all have, to various extents, certain issues. I mean, I don't know that there are what I would call great witnesses here. By all accounts, they're not even calling their own medical examiner from the first trial and who performed the autopsy because her conclusions don't support them. One wonders if they're even going to call Proctor at this point, who they tried to hide, which was, in my view, a tactical error by not gaining trust, with the jurors by letting them know that I'm not going to hide anything from you. There are some things in this case from our standpoint that are not perfect, and I want to be the one to alert you to that. I want to wear the white hat because I want you to think that I'm honest and credible, not as a witness. Obviously, his credibility doesn't matter in that regard, and it's improper to put his credibility before the jury. But when he's making arguments, you want, if you're a prosecutor, you want the jury to trust you and like you. and
Right.
hiding people as like Proctor kind of can betray some of that, take some of that trust away, but also it's serving an 88-mile-an-hour dead straight fastball down the middle of the plate to Alan Jackson to whack out of
Yeah.
Now that you mentioned that, that was the elephant in the room that Mr. Brennan did not even mention Mr. Proctor. And I love the analogy that you just drew, that it's like throwing an 88-mile-an-hour pitch to Alan Jackson. Let's take a look at the swing right now that Alan Jackson took at that fastball.
More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home.
So my next question to you is your response to that, obviously, but also which side is going to call Mr. Proctor? Any idea?
Well, I mean, the fact that Brennan didn't mention him, I mean, is that a tell? I don't know. I mean, at this point, if he doesn't, it looks terrible. Now, it looks terrible if he calls him too. I mean, the guy is a disaster for their case, and it's kind of a we're damned if you do, damned if we don't kind of thing with Proctor. It's why I call him the albatross. He's literally just wrapped around their neck, and there's no way to divorce themselves from him. And I mean, Alan called him a metastasizing cancer, literally in the sense that everything he touched in this case just grew foul, and the stench and the corruption that they're alleging all emanating from him and his involvement in the case. So I have no idea if the prosecution is going to call him or not. My gut is they probably won't, because they're going to come out on the fact they know the defense it's already out there. And at least that would require the defense, for the beginning anyway, unless something happens, to have to conduct a direct examination of Proctor rather than a cross-examination, which I think would be much more difficult. That will be extracting information in a more difficult way rather than just bludgeoning him over the head again and again and again, like they did the first time and presumably would do this time, because he's worse. I mean, now he's terminated. He's terminated for having potential bias against this particular defendant in this case, where they are alleging there's corruption. So that's a disaster. And now he's on the hook as the patsy for all the missing video that you learned in some of the hearings from a few weeks ago. So he, as bad as he was the first time, he's that much worse this time. So as far as the opening that you just played, the difference between these two lawyers and their likability with the jury, I think, is just off the charts. It couldn't be more different. And it's an interesting thing because, on the one hand, Brennan essentially memorized his opening, whatever. That's impressive. You can, in theory, that's a better way to connect with jurors, to kind of look them over, walk over here, look at you. But the manner of delivery was so monotone, very drone-like, no inflection at key points. It was just kind of a nasally throughout without any inflection or any change in anything, as compared to when you see Alan do it. There are a lot of pauses. There are a lot of change in tone. There's much more emphasis to the jury about what he's saying, and it's just a more powerful pitch, if you will. And I think it also makes him look more credible, again, in the sense that he believes what he's saying and that this is important and we think this is wrong, as opposed to a, again, very methodical story about, Officer Nuttall heard the bell and went to the call. I mean, it's just blah. I mean, it's like soggy cereal,
Yeah.
right? It's nothing.
And Mr. Nuttall didn't hold up very well on cross-examination, not to mention that,
No.
I mean, it's silly, but it's important. The last trial a year ago, we talked about how John O'Keefe had a puffy jacket. Well, it's been proven that John O'Keefe did not have a puffy Michelin Man coat on at all.
Right.
And confronted with that, he said, well, my memory's better now, 3 years after the incident than 2 years, which made zero sense to anyone.
No, it makes no sense. They knew the puffy coat thing was going to be there. That's why you knew he was not going to be a great witness. And to lead off with him when you are, I mean, I know what he's trying to do. He's trying to get out the evidence of, the purported, I hit him, and lead into that and follow up on that. But, we laugh at the puffy jacket thing, but the point is a big one in the sense that a year ago, he said, I am as adamant about that as I am about hearing I hit him and anything else. And obviously it was not true. And obviously he was mistaken. I don't think he was lying at the first trial deliberately to put a coat on a man that wasn't wearing a coat. But when he locks down and says, I'm positive, as much as I am about she said I hit him, by the way, twice the first trial.
Right.
That's just a walking impeachment into the next trial. And, you add on other layers to the jacket, no pun intended. But, now he says, well, my memory, as you said, is better now than it was a year ago and 3 years ago, which is patently absurd. And this is why he now remembers that it was 3 times I heard Karen say I hit him, which, they have to sync that up with the other witnesses. And you get the extra detail. He says, well, I remember that after talking to Brennan and Tully,
Oh my God.
talking about this. So now I remember it. That's going to discredit him further. And then the final thing is when he uses so much visual detail. And I remember I had the mask and my partner was doing chest compressions and was kneeling down. And then they introduced the videos of, you around the mask and your partner doing chest compressions. And the video has the misfortune of having sound. And what you don't hear is I hit him.
Right.
And the witness wants to argue. I mean, argue's not the right word. I mean, he's not a professional witness, but really dig in that, well, it must be over here or it happened then, but it's not on the video. And you're just left with, this is the guy that they're using to anchor or tether their whole case around to start this series of admissions that they're clearly trying, alleged admissions anyway, that they're clearly trying to use. And the first 2 witnesses who they tried it with, both imploded in spectacular fashion.
Yeah, and speaking of things that are not on video, let's take these witnesses in order. Then Carrie Roberts comes in, and I almost fell out of my seat when I heard her say that when they went over to John O'Keefe's house looking for him first thing in the morning on January 29th, 2022, Karen Reed pointed out to her, according to Carrie, that there was a piece missing from the taillight on the passenger side of her Lexus SUV, and there was a piece of metal. And Carrie said she was afraid people were going to, cut their jackets or whatever. And then when Alan Jackson skillfully played the video of them all, the 3 of them arriving over at One Meadows, it didn't happen.
No, and
Happen.
She wasn't cross-examined at the first trial for, reasons that are perplexing to most people in light of what you certainly know about her now. There's no question that all of that testimony about looking at the taillight before they went in is demonstrably false. And then, what does Brennan do? He plays a video where I guess Karen says in one of these outtakes, well, at some point I did show her the light. And so, in some sense, he rehabilitates the idea that maybe Kerry saw the taillight. But the larger problem with her really is her story tracks with whatever McCabe's story was changing, and they go hand in hand. And, for lack of a better term, she really presents as a McCabe stooge. And I mean that in the sense that, just kind of like her flunky. I mean, that's how it appears based on what you saw. So, for example, when she speaks to the cops a few hours after the incident, her close childhood friend, John O'Keefe, is dead. She's very upset. This is Kerry Roberts I'm talking about.
Mhm.
That's understandable. She obviously wants whatever happened to him to be discovered, whether it's natural, unnatural, murder, not, whatever. Cops come over and she's given the opportunity, just like, tell us what you know. There's nothing about taillight cracks. There's nothing about the condition of the taillight. There's nothing about Karen showing me the taillight. There's nothing about I hit him, did I hit him, any of this. And that's like what you would say, but that's Kerry Roberts, BM before McCabe.
Yeah.
By the time, the story starts changing and the next time the cops are with her, she's been hanging out endlessly with Jennifer McCabe. She prepares this, timeline, which is bizarre beyond belief that why they would even be doing that. And her story continues to grow into synchronizing with the evolving story of Jennifer McCabe. And it culminates in this grand jury testimony about saying, I heard, Karen asked Jen to, do a Google search. And she even started saying how long and said, oh, it was for hypothermia. So this was obviously something that, Lally had prepped her to say they were going to do this. He didn't just ask randomly. And when the FBI comes calling, and anybody who deals with the FBI knows how this works, you get what they call 1001 warnings. They tell you it's the Martha Stewart crime. Okay, it's what everybody knows it as.
Mhm.
If you lie to us, if you make a materially false statement to us, it's a crime. It's a federal crime, and obviously anything related to the Google search would be a material statement because the whole case can hinge on it.
Sure.
And when they tell that to Kerry for the first time, she says, I never heard that. And she doesn't offer any explanation about, well, I said it earlier because, I thought, he asked if I had heard it from, Jennifer McCabe, and my job is to testify, to report what other people told me. I thought that's what you were asking me. That's absurd. And I think her explanation was absurd. I mean, I don't think she's going to get charged with perjury or anything like that, but she is thoroughly discredited. I mean, entirely. And I don't think the jury is going to put any stock in anything that she has to say regarding observations and things that she heard that in any way could be harmful to Karen unless they occur, BM before McCabe.
It was almost jaw-dropping to hear how many times she had actually met with District Attorney Morrissey and with Hank Brenan and with Jennifer McCabe. But I want to move on to the next witness. In preparing a case for trial, attorneys look at the elements of the cause of action or the crime and what evidence they really need to support each element of each charge. Was there any need really, from a legal technical point of view, for Brenan to call Ms. Peggy O'Keefe? And how do you think that played for the jury?
Well, I mean, it's kind of an interesting thing. Did he need to call her? No, of course not. Why did he call her? I think to try to bootstrap the video of Karen making a face in which she's purporting to describe how Mrs. O'Keefe acted towards her. So I think it was just an end around way to try to make what I found a ridiculous argument of, consciousness of guilt or whatnot about that. He obviously was trying to use Mrs. O'Keefe, and she bought into it because, a lot of her testimony, I think, was inappropriate, but the defense made a calculated decision. We're not interrupting the mother of someone who has had more tragedy than anyone you'll ever meet in your life. There's no question, two children, all that stuff. It's just horrifying what she's been through. But, this idea that she was suggesting that Karen and her father, who, if you've ever met him, is like the nicest guy you'll ever meet.
Yes, I have. Yeah.
Were upstairs. He's very religious, by the way, which is will be a factor and why I don't think they're ever going to call him. But to imply that they went up there within a few hours of what happened to John O'Keefe to tamper with and destroy evidence, and then, move the murder weapon by concealing it. By the way, concealing it in my father's driveway with the right rear taillight sticking out facing the street. So anyone who would ever go to my father's house would see it. I mean, that's not exactly a very good way to conceal evidence, I would suggest.
Yeah.
No.
So I think they called her for sympathy and to just kind of dirty up Karen.
I don't know if that really works with the jury. I really don't. I think it's kind of obvious. The text messages between John O'Keefe and Karen Reed from January 28th, 2022 indicated obvious tension between the two of them. O'Keefe was unsure whether he even wanted to see her, but they did actually meet that night. Obviously, do you think anything of real actual relevance came from that? I heard it said that, couples fight. Couples do fight, and they kiss and make up. So do you think anything really significant came from all of those text messages that took Nick Carino so long to read?
No, I mean, this was a question that was posed to me actually this morning by the host on a Fox News discussion about this.
Did not see that.
Well, it'll be available online later.
Okay.
No, I mean, I think anyone who has ever been married or had a significant other for a great period of time will recognize that there are times that not everything is peaches and creams. A lot of times there is a little bit of either tension, frustration, argument for any number of reasons. And those text messages, what you saw were a couple bickering. And, to the extent anybody looked bad in those text messages, if you even go down that path, John looked worse than Karen. And I'm not saying he looked bad. That's not what I'm saying. But she clearly was trying to engage him in a discussion about, let's work through whatever these problems are. And he clearly was just blowing her off. I mean, I think he used that, eye rolling emoji 5 times, just, and I don't want to talk to you. And it's, the kids are here. My father is here. There's, any reason there can be not to do it. But if that's leading up to your motive for murder a few hours later, I think that's quite a big misjudge, a misread. No pun intended on that. They did it in the first trial too. I give him credit for doing it the way he did it in this trial. At least it was less choppy. But I'm not sure it helped them, because when you read them all over the course of the several hours, what do you see? You see people going through some stuff. Maybe the relationship isn't working out, but there's no homicidal lunatics here.
No.
Yeah.
No.
Well, you touching on a lot of things that I was thinking when I was watching Brennan's opening statement, because the way that, when we first watched it, I was trying to just approach it from a neutral standpoint and be unbiased. But then I was watching it again because I was getting a screenshot for one of our thumbnails. And I found myself getting uncharacteristically mad, because with his opening statement and just the way he's talking, I'm just sitting there getting PO'd thinking has this man never been in relationships where he's having these quarrels, is having a difficulty in a relationship? Is he truly perceiving that as a motive to off someone? I thought the whole grounds of the argument is insane. But then at the same time, I'm sitting here thinking, if I'm the jury and this person's introduced to me as Whitey Bulger's former attorney, it's he was protecting the mob once. That my impression is that he's just doing it again, is how he comes off.
I would be concerned about how he portrays himself. I don't think he doesn't give the warm and fuzzies, but more important than that he doesn't give off or reek of credibility. And this goes back even to some of the things he said in the opening. I think he said the Nuttall thing was going to be on video. No, it wasn't. And you've seen him in the pretrial motions making all kinds of statements that are just not true, or are reckless and whatnot. And, so I'd be concerned that the jury is just not going to take you at face value. You didn't tell us about Proctor. He barely mentioned Jen McCabe in the opening, which was interesting. Never mentioned Brian Higgins.
Crazy.
Barely, if at all, mentioned Brian Albert. These are the issues that I understand you don't want to like defend against something that hasn't been brought out yet, but how do you not get into Jennifer McCabe at all? I mean, it's kind of an important thing that you're just going to have to deal with. As far as what he's doing with these text messages, it's also ignoring the fact that they went out that night. They're clearly happy on the video. Every witness is going to say they're happy. And then by the time he gets into the other messages that get, I guess, worse, if you will, after, Karen drops off John or whatever happens at the house. And there are those angry messages where she's kind of yelling at him. And then the risk, though, is those messages, which will come out at some point, those start morphing from anger into panic about like, where are you? And that's not consistent with somebody who knows that she just mowed him down. And the anger messages, I think, can be explained or will be explained, I assume, in that, you just left me there and you just went inside and I'm standing out here. And it's going to explain her conduct without her having to explain it herself. Because, I mean, she's not going to testify. We know that. So I don't know that this is helpful for them.
I don't know. There are people out there that think that she might testify. I mean, she did all of these media interviews. But before we get to that, I wanted to take this in some kind of order. The week closed out with Adam Lally actually taking a witness. He did the direct examination on Friday of Dr. Gary Fowler. What is the significance of Mr. Lally actually getting up from his heretofore, in this case, retrial, inactive role? He actually got up and did a witness. What's the significance of that? Any?
Well, I don't know if there's any significance. I mean, it's kind of humorous in light of the fact that, look, there was video from, I think it was either the first or second day of jury selection where, Brenan was introducing his colleagues. Apparently, they can't introduce themselves. They need a hall pass to speak. But even when he introduced Lally, he said nothing. He didn't even say good morning, members of the jury or whatever. And so at this point, if he's going to sit, and you can see it on the video, I mean, if he spends 90% of his time aimlessly staring at the back of the bench that Cannone is sitting on and twirling pencils, that's a terrible look. So better, if you're the prosecution, that he do something, however trivial or unimportant it is. I think they look better by having each member of the team do something. But I don't think it's going to matter.
Speaking of twiddling pencils, is there any significance to the fact that Laura McLaughlin wasn't even there for the opening day? Apparently she's off on vacation, the third prosecutor.
I mean, if she's on vacation during, a retrial of a murder case like this, that's bizarre. On the other hand, I don't know what everyone's personal schedules and preferences are, whatever. If she comes back, she'll come back. I personally would not want the jury seeing my team piecemeal come and go and whatnot, even though they wouldn't know that I had to go on vacation, if that's the case, rather than deal with you. I mean, if she has kids, I mean, it can be any number of reasons. Everyone's entitled to vacation. But if you're trying the case, you're trying the case. And I would be concerned just that the table is coming and going. It doesn't send a very collegial or organized manner of prosecution. And they appear to be three individuals handling or sitting there at the table rather than a team. I mean, you look at the defense, they huddle up, they do this, they've got this one doing that one, this one's doing this, they consult with each other. You're not seeing any of that at the prosecution table at all.
No. One of our commenters said that one of our commenters questioned, isn't the defense clearly signaling that they are going to be more aggressive in the retrial? Is that an indication that they've made a strategic mistake in the first trial, thinking that the Commonwealth's case was so bad that they didn't really need to directly address it, and so now they're being more aggressive? For example, the cross-examination of Carrie Roberts. For example, on Friday, Elizabeth Little made a very aggressive cross-examination of the doctor, at Good Samaritan Hospital who was just there to give the blood alcohol. Do you think the defense feels like they made a mistake by not being too aggressive in the first trial?
I mean, anytime there's a retrial, I think you're always going to take inventory about there are certain things that, we'll do differently, whether it's, lamenting a lack of aggressiveness at the first one. I mean, I do think they're a little zestier, and that's good. I mean, as long as you do it in a professional way, they've got a woman's life at stake, and their aggressiveness to me really has to be dictated by the witness. So, when some people were saying, well, why was some of these, what do they call them? Law tubers, or I don't know even.
Right. Law tubers.
Wondering whether Alan was too aggressive with Nuttall. And my response was, he had to pull teeth to get him with the video. Would you rather him just be a happy, smiley guy and not make the point to the jury that this witness is not credible? And I don't think it was that aggressive anyway. The stuff with Kerry Roberts, she was getting upset and aggressive and very sensitive about, the story about her, false statement in the grand jury and all that. I don't think that was offensive in the least. On the other hand, they obviously made a conscious decision to leave Mrs. O'Keefe alone, no matter what. She could have been cross-examined about a lot of things, but they decided that's going to be a bad look. But in doing so, got up, expressed condolences, and then sat down, which I thought was a very smart tactical decision, just to let the jury know, we can be human too, that sort of thing. But I don't think that they're being over aggressive at all. And the reality is, if the situation calls for it, you have to do whatever it is to do to defend and protect your client. If you can do it with a smile and everybody be buddy, well, that's always preferable, but that's not how trials work.
And Alan Jackson is really skilled at cross-examination. While I was watching the cross-examination with Mr. Nuttall, the EMT, and Alan Jackson had to re-ask the question several times. And the more he re-asked the question, the more Nuttall was backing away from it. And I thought, I've been in that situation, and it is tough, and you don't know how far to press it before you PO the judge and the jury because they're saying you're too aggressive, or whether there are those on the jury that are saying, keep going, you got to get that answer. You asked a question, just keep going. Not to mention the network you appeared on, Fox, but sometimes I get a little bit disappointed, not just with them, but with other journalists. They'll ask a question and they'll let the person that they're talking to run the clock by just talking about something else. Then they'll go on to something else or a commercial. So that's a pet peeve of mine. And I thought Jackson was very skilled in re-asking the question over and over and over. And it's tough to know where the balance is.
It is. But if you have to get the answer you need, and the only way to get it is by pushing the pedal to the metal with the witness, then there are times you have to do that. I mean, I don't think the jury's going to hate them for that. I just don't see that.
I don't know. I think a lot of people do hate us. I think a lot of people, as juror Ronnie had said about the jury talking about distractions. A lot of the things they were establishing reasonable doubt, and the jurors just thought they were distractions. So I often wonder what the jurors are really thinking about us.
Was if whether it was too aggressive or not, was establishing that Nuttall's credibility and reliability on I hit him was not reliable and not credible. So that's certainly the whole point of the DA even calling him as a witness. So, he was on the key point when he was turning up the heat.
Now, in the opening argument, Mr. Brenan did play one cut, and then he played some other cuts of Karen Reed. And I don't know, she has the best team that she could have. They're great attorneys. They're way above my pay grade. I don't question them, but I just wonder, the wisdom of letting her do those interviews, but B, they were played, and I've talked to Karen Reed, and she doesn't sound that whiny. She sounded so whiny in that cut. In one of the cuts, she wasn't mic'd. The microphone was across the room. And, having been in the TV business before, if you don't like somebody, you can make them look bad. The camera angle, the lighting, all kinds of other factors. And at this point, with Brennan just playing these clips at random so far, how can the defense team contest that? Can they say anything about this? They can't impeach her. It's already on tape.
Well, I mean, in the first observation is they made a mistake in letting her do this. There's just no way around it. I mean, case is not resolved, client talking again and again and again. And most of the time, outside of the presence of her attorneys as well. Obviously, they thought they were going to win or this and that, and this would never be an issue. But here we are again, and these are now coming back to some extent. I don't think to great effect, but to some extent, they're a headache for her. And you know, the reality is 1 week through the trial, if you said to me, what is the most, to the extent there's any, powerful evidence offered against her thus far by the prosecution, and I would say, you know what, it's the video clips, which shouldn't even exist, right? I mean, if she doesn't do it, they don't even touch that. But if their strategy is to call a witness, have that witness destroyed, and then try to play a clip that kind of, sort of, but not really rehabilitates maybe one point on which the witness was destroyed. I mean, the DA, they're not going to win that way. They're going to need real evidence at some point that's not just her talking. What can the defense do? I mean, there is a rule of completeness that, you know, all lawyers are aware of. I mean, if there are parts of her statement that were played that are, you know, a part of a larger statement and are taken out of context, they would have the right, you know, to finish, as long as it's relevant to that topic that was introduced, to do that so that the jury could see the whole thing. Will they actually do it or not? I mean, for, you know, one example is, you know, Karen said, I had some drinks. You know what? There's video footage from the bars of her having drinks. There are receipts.
Sure is.
There is a blood alcohol, although it's not the most reliable testing, clearly. Right. But I mean, so I'm not sure that's the hill to die on, like dealing with that. The one clip that I found just ridiculous is the one in which, you know, she's talking about Mrs. O'Keefe. How the hell the judge allowed that one in is beyond me. I think that was outrageous. I don't think it's relevant. I think to the extent it was relevant, certainly its probative value was substantially outweighed by its prejudice. It does not evince consciousness of guilt. I mean, that to me was just, there was no reason for that. And that's an issue I'm sure they're flagging in a, you know, the unplanned for event of an appeal. But that's what they can do. I mean, if they want to complete the videos, they can. But I also think what Brennan is trying to do is smoke them out of their cave and try to force their hand to make her testify. But
yeah, you're probably right about that. You're probably absolutely right about that. I think that clip was the only reason for that clip was to make Karen look bad.
Yeah,
that was the only reason. Yeah. Let's stipulate to that.
Yeah.
Something we can't stipulate to is ARCA. Now, Hank Brenan has said, my intent was never to keep ARCA from testifying, but there's going to be another, as we sit here now, there's going to be another voir dire of the ARCA people on Monday. They've got to fly up from Philly. And Mr. Brenan had actually filed all right, I'll be more objective and not say it's a bizarre motion, but he filed a motion to delay the trial until June 1st. Now, that's not going to happen. There's zero chance of that happening, is there?
No. Listen, to see him, and this has been going on a couple times over the past couple of weeks, to express this faux indignation about the concept of, I can't be ready for trial because I need to know what the ARCA experts are going to say about my expert. And I need to prepare that. And if I can't, then I can't go forward. Now, the most obvious observation to that is you really don't feel good about your expert, do you? Because they should be unassailable or unimpeachable. I understand you want to know and deal with it, but when every time he whines about this, it's just a master class in gaslighting, because he's talking about how the defense is, you know, they're unethical, they're not doing this, they're you know, violating all these discovery statutes, and there has to be severe sanctions. And you sit there and you say, guy, have you been watching the last 2 years of what the hell has been happening in this courtroom with discovery shenanigans and whatnot? The defense couldn't even get a hearing on the motion to dismiss for the disappearance of evidence. But when it comes to ARCA, we're going to drop everything. Let's get him here tomorrow from Philadelphia and get to the bottom of this. So the other thing he ignored in that whole argument is that if you listen to what Bob was saying, or maybe a few days ago, in kind of replying to this, the timeline was really screwed up by the prosecution. They were very late. These guys got what they needed. They moved it along as quickly as they could. They still don't even have the information that they need to get a report to give to the DA. And Brenan literally has the judge looking at the defense saying, I'm on the cusp of throwing this out or sanctioning you in some way by restricting their testimony. And I'm doing you a favor, you, Karen Reed, by giving you the chance to have this hearing, when even the defense was like, why are we doing this hearing? What is the issue here? And the judge said, you tell me. I'm doing this for you. This is a favor because I'm this close. So, it's crazy, I think.
Isn't it just a matter of the other side always trying to throw roadblocks in front of you? I've often found, especially in a large case, when I'm up against some huge insurance mill, and we all know who they are, in the final weeks and days before trial, they'll file motions out of nowhere just to distract you from your trial preparation. In my view, that's all it is.
And there is no way that this judge is going to sanction the defense in the form of restricting the most exculpatory witnesses that they could possibly have from giving a full opinion. And if she did that and there was an appeal, I mean, that would be a very serious, due process violation on a right to present a defense and an overreaction. And frankly, I don't even think her factual findings that the defense acted improper here, I don't think it's supported by the record, at least not the record she's made. So it's probably an abuse of discretion anyway that an appellate court would say for her to even make these findings.
Well, no, I listened really closely to Bob Alessi's argument. You're on a first name basis with him. I'm not, but I listened to his argument when the whole ARCA question was coming down. He specified carefully, thoroughly, methodically what happened, and there was no reason for any grave concern by anyone, really. I just think it's a last minute distraction, as Ronnie would have put it.
Oh, it is.
The jurors don't see that.
The judge gets all concerned about these, where are these text messages? They're deleted. They're, presumably they're ministerial. They're deleted. But the bottom line is we don't have them. And that's a matter of, grave concern. That's the buzzword in this case. Everything's a matter of grave concern.
Grave concern,
but
yeah.
when the shoe is on the other foot about like the missing metadata because they didn't preserve the Sallyport video properly, and the defense says we need to see that to know who did what, who touched what, and she says, well, there's no issue there. That seems like just not. Well, I'll let you draw your conclusion.
It's crazy. It's crazy. That courtroom, you've been in it a number of times. I actually tried a case in that courtroom. It's so tight. I actually tried a case in there a number of years ago, different judge. It's so tiny. One of our commenters asked. Now, of course, the defense team wanted it moved from the big courtroom down the hall to the little courtroom because in the big courtroom, some of the witnesses couldn't be seen by the jury. But does the advantage of the small courtroom so jurors can observe the witnesses better, does that outweigh the discomfort of the O'Keefes being so close to Karen? They're always, especially Paul, is always glaring at Karen, and David Yannetti, sits between the two of them. But is it advantageous for them to be in that little courtroom?
So I feel like it's an impossible choice because it shouldn't be either or. Number one, they're entitled to a room in which the witnesses can be seen by every juror. I don't think that's like rocket science.
No.
Body language can be more significant than, words coming out of their mouth. But then, who could have foreseen when you get moved into this closet courtroom that not so much even Paul O'Keefe looking at Karen and all that. My concern would be the jury is staring at Mrs. O'Keefe the whole time. And she just testified. And, all of this, in most normal courtrooms, obviously, both sides would be behind the parties. And there's at least an appearance of neutrality in that, we don't favor anything. Somebody had to sit somewhere in that little courtroom. I get it. But I think having the jury looking at literally all day at the O'Keefe family and their friends and supporters that's a disadvantage. But I don't think it's as much as a disadvantage as it would be for some of these witnesses with their demeanor issues, not being seen by certain jurors. I mean, I agree with the defense. If you had to make the choice, you hold your nose and do this the way it is now. But that's not saying this is an acceptable set of circumstances either, because it shouldn't be.
As an insider, which you are, what are we going to see in the week or weeks ahead? Do you have any inside view of what's coming up? Any fireworks, or is it just going to continue to roll along as it has?
I mean, I don't know scheduling or those sort of things, and certainly this case is a little interesting in the way they're calling witnesses. It is not what Lally was doing last time, which was we're going to do all the cops, then all the first responders, and kind of compartmentalize different issues. As far as I can tell, what Brenan tried to do at the end of the week was convince the jury of two key facts in his mind: that she admitted hitting him and that she was intoxicated. And that's where, that the witnesses that he's calling, that appears to be the path that he's navigated. Again, I don't think the witnesses have certainly given him any credible evidence that I hit him, but he'll argue, but Karen does, based on some of her statements. But where he goes next, I don't know. I hate the fact that they went to the crime scene early again, like they did last time. I mean, telling the jury, look out for this, that doesn't do it. The jury needs to know that, Jennifer McCabe and Matthew McCabe and all these other people inside the house, they didn't hear anything when this was happening, 20 to 30 feet in dead silence on the street in front of them. They need to know to focus, look at that path they walk out to get into their car and drive by, and there's supposed to be a body here. How did nobody see that? They need to know that, Brian Albert and Nicole Albert, who have no hearing problems that anyone's aware of, have bedroom windows that if you've ever been by this property, if you opened up Brian Albert's bedroom window, he could spit onto the flagpole if he really wanted to. I mean, I'm not literally, but it's that close. It really is that close. And the other thing that I would want emphasis on is the next door neighbor is on the witness list for the defense. And there have been pictures that have already been put out in the public realm. They did wake up, okay? They did come out. They did take pictures of the hook and ladders and police cars, and their area was much farther away from all the activity than where Brian, Nicole Albert, and the dog were.
The dog.
Well, that's, because, I have two dogs. You probably heard them, not today, but in the past, they bark at anything. So to me, it's the prosecution's advantage to go do this now. And the only evidence he's put forth is, the Kerry Roberts and EMTs, this is where the body was. So the jury will get an understanding of that. It's fresh in their mind, but not all this other stuff. And I don't know if this was discussed or if there's even another visit planned. I mean, if I were the defense, I would argue to go back during our case when, but we'll have to wait and see what they do.
I guess early on Friday, both David Yannetti, I believe, made the argument, and Hank Brenan were able to tell the jurors, here's what to look for. Look up there, look over here. The Lexus will be there. Look, he didn't come right out and say, look at the size of that vehicle, but words to that effect. So, but you're right. There's no parallel for actually sitting there and listening to all the testimony.
Jurors who are they're literally the fact finders. Okay.
Right. Absolutely.
And to take them to that scene and not allow them to have the evidence of no one in that house woke up. They ought to have heard that testimony. They ought to have been able to hear whether any of these witnesses had hearing problems or there was noise, and then process that in their minds. Look at the window, look at the fire hydrant, the flagpole, look, and actually fact find. And when you're bringing them to the scene with minimal information, how can the benefit be as great to the fact finder than if they had the relevant information that makes all of these issues important? They don't even know about it.
Yeah, I do have some friends and an extended family member who are law enforcement. One of them is now a lieutenant. And in my conversations with them, if I asked them, if a body were found in my front yard, wouldn't you guys be trying to get in? And they're like, absolutely. And if you wouldn't let us in, we go to court, we have probable cause, and we'd be in there. So it's just, it makes no sense. So I know that you're a busy guy, and we always try and get you out of here. Lainey, do you have any closing thoughts for Mr. Bederow?
I mean, we touched on a lot of the things that I was thinking, but I'm still just, and this is, I guess, not necessarily a closing thought for you, Attorney Bederow, but just the fact that we touched on Karen Reed's blood alcohol content, and it's kind of like we just ignore the fact that every other law enforcement officer and their mother in this case had a high blood alcohol content and was also running around in their cars. So it's just a lot of, it just almost seems just like hypocrisy, and it's just, it really, at least for me as just someone watching this without a law background, I'm just sitting here thinking that it just does seem like Brennan is just covering up for the cops. And I don't know if the jury's going to feel that way, but I would kind of hope to see that the defense harp more on that everybody else in this case is wasted. It's ridiculous.
One of the sad tragedies of this whole thing, and this is really pathetic for all of them involved, is the central role that alcohol plays in these people's lives to socialize. I mean, when you see everywhere they go, every place they do, I mean, these are adults in their, 50s, and every social setting seems to be wrapped around drinking. And it just, even when they go out at night, we got to come back to the house and, pound a few more. And, take a guy like Higgins from the first trial, if you even take him at face value. I left, not because, I didn't want to hang out with my friends anymore. They didn't have any Jameson and ginger. So I got out of there. I need to drink my thing. So if I'm not going to drink more, I don't want to hang out with these people.
Well, it's Massachusetts, and as you well know, being a native, now having this intelligence to move down to New York, there's a packy on every street corner, and there's a bar on every street corner, unlike in New Hampshire where, they're spaced out a little bit more. Attorney Bederow, I have one bone to pick with you, and that is, most times that you appear on our podcast, and we thank you for that, you're informal, and I have a suit and tie. So anticipating your arrival today, I decided, well, maybe I should go informal. And there you are with a suit and a tie. So next time, if I'm lucky enough to have a next time with you guesting on our podcast, could you have your people talk to my people? And
we'll get our wardrobes all squared away. Yeah, definitely.
I'll start wearing a suit and tie with you guys.
Thank you so much for your time. Be well. And, keep watching it. Keep watching. Yep. Thank you.
Take care, guys. Bye.
Thank you.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
Five minutes, Mr. Alessi.